Hello and welcome back to the Daily Deep Dive. I am your host, and I'm so glad you're joining us today.
It's great to be here.
We are the place where we take these incredibly dense, complicated, and let's be honest, sometimes really intimidating subjects.
The kind of stuff you feel like you should know, but
never quite get around to reading.
Mhm.
And we try to turn it into something you can actually use. Today, we're not just looking at a rule book. We are, I think, looking under the hood of the machine that runs the world's largest democracy.
that is absolutely right. And honestly, if you live in India, or even if you're just fascinated by how a nation of over 1 billion people works, this is probably the single most important document you could ever look at.
We're talking to fundamental rights. But, I mean, for most of us, the last time we seriously thought about this was maybe in 10th grade civics class.
That's usually the case.
We have this vague idea that we have rights. You know, we can speak freely, we can move around.
Mm.
But do we actually know how to use them? Do we know where the lines are?
Most people don't. And it's a bit like owning a supercar, but never taking it out of first gear because you haven't really read the manual.
So today, that's what we're doing. We're doing a serious deep dive. Our source material is Chapter 7 of Indian Polity, and we're zeroing in on Part 3 of the Constitution. That's Articles 12 through 35.
And we're framing this whole discussion around a pretty heavy title.
The Magna Carta of India.
And, you know, it's a title that is completely earned, just like the Magna Carta back in 1215 was this first real check on the absolute power of the king in England.
Right.
Part 3 of the Indian Constitution is the check on the power of the state. It's the wall that stands between the individual and potential tyranny.
So the mission for this deep dive is pretty simple. We're going to try and turn legalese into actual leverage for you. We're going to figure out what these rights really mean, where the loopholes might be.
There are always loopholes.
Always. And most importantly, what happens when the government tries to cross those lines.
Exactly. And to start, we have to understand where these ideas came from. The framers of the Constitution didn't just, invent them out of thin air.
They were looking around the world.
They were. They took a lot of inspiration from the Constitution of the USA, especially its Bill of Rights. But, and this is a key point, the Indian version of fundamental rights is far, far more elaborate than what you'll find in the American Constitution.
That makes a lot of sense, really. I mean, given the sheer complexity of India compared to the U.S. back in the 1700s. But before we jump into the specific articles, there's a word that keeps coming up in our source material. Justiciable, it sounds. Very lawyerly.
It does. It sounds like something a lawyer would charge you $500 just for saying the word.
Right. So let's unpack that. What does it actually mean?
Well, it might cost you that in a consultation, but the concept itself is the most critical one here. Justiciable just means these rights are enforceable by the courts. They aren't just, polite suggestions or some moral guidelines for the government to follow. If the state violates your fundamental rights, you don't have to wait for the next election to complain. You have the right to go straight to the courts to get them enforced.
And not just any court, right? We're talking about the top.
Correct. You can actually bypass the entire lower judiciary and go directly to the high courts or even the Supreme Court of India.
Wow. That's a kind of superpower. Usually the legal system is this long ladder you have to climb, rung by painful rung. But for these rights, you get an express elevator right to the penthouse.
That's precisely it, because these rights are the bedrock. The core mission, as our source defines it, is to promote the ideal of political democracy. They are designed specifically to prevent authoritarian rule.
To stop a despot from taking over.
Exactly. The goal is to establish a government of laws and not of men.
I love that phrase. A government of laws and not of men. It means it shouldn't matter who the prime minister is or who your local bureaucrat is. The law is supposed to be the boss.
It protects the dignity of the individual. But, before we get to the really exciting stuff like free speech and equality, we have to define who we're being protected from. Who is the potential villain in this story?
That brings us to our first section and Article 12, defining the state.
Yes.
Because when I hear the state, my mind immediately goes to the Parliament building in New Delhi, or maybe my state's legislative assembly. But the Constitution says, no, you need to think much, much bigger.
Much bigger. Under Article 12, the state isn't just the central government and parliament. It's also the government and legislature of every single state. And then it goes local.
So my local city council, my panchayat.
All of it. Municipalities, panchayats, district boards, improvement trusts, they are all the state. So if your local municipal corporation passes some rule, that's discriminatory.
That's a violation of my fundamental rights by the state.
Yes, absolutely. But it gets even wider. The article includes this phrase, other authorities, and the courts have spent decades defining that. It means statutory or even non-statutory bodies, like the Life Insurance Corporation, LIC.
Wait, a company like LIC counts as the state?
In this specific context, yes. ONGC.
Okay.
Sale. The Supreme Court has ruled that even a private body or an agency that's working as an instrument of the state falls under the definition of state in Article 12.
Okay, that's a huge distinction.
Yeah.
So if the government decides to outsource, say, a public service to a private company, that company can't just turn around and say, hey, we're a private entity. We don't have to follow the Constitution's rules on equality.
Exactly. You can't outsource oppression. That's the principle. If you're doing the government's work, you have to play by the government's rules.
Okay, so we know who we're watching. Now let's talk about the weapon we have to watch them with. Article 13. This feels like where the real teeth are.
It is. Article 13 gives us the doctrine of judicial review. It says very clearly that any law, and it means any law, that is inconsistent with or takes away from any of the fundamental rights shall be void.
Void. Null. Just gone.
Dead on arrival. Correct. The Supreme Court and the high courts can declare a law unconstitutional and invalid.
And law here doesn't just mean a bill passed by Parliament, does it?
No, it's defined very broadly. It includes ordinances issued by the president, orders, bylaws, rules, regulations, notifications, even a custom or usage that has the force of law.
So if there's a village custom that says, for example, people from a certain caste can't use this public well, Article 13 says the custom is void.
Yes, because it violates the right to equality. Custom cannot override the Constitution.
But this is where it gets a little bit tricky and really interesting. Can Parliament change these rights? I mean, can they just pass an amendment to the Constitution and take a right away?
That was the million-dollar question for decades. And Article 13 says a constitutional amendment is not a law in the ordinary sense, which created this huge tug-of-war between Parliament and the Supreme Court.
So Parliament was saying, we're elected by the people. We have the power to change any part of the Constitution we want.
And the Supreme Court was saying, not so fast. This whole conflict, this back and forth, it all culminated in the legendary Kesavananda Bharati case of 1973.
Probably the single most important legal judgment in Indian history.
Without a doubt. The court, in a landmark ruling, said that yes, Parliament can amend fundamental rights. However,
It was a big but.
a very big but, they cannot alter the basic structure of the Constitution.
So there's like a do not touch list inside the Constitution. It's like renovating your house. You can change the paint, you can replace the windows, maybe even knock down a non-load-bearing wall.
That's a perfect analogy.
But you cannot touch the foundation. You can't blow up the load-bearing columns.
That's it. And things like the secular character of the state, the rule of law, the separation of powers, these are part of that foundation. They're off limits. Even if 100% of Parliament voted to change it, an amendment that violates the basic structure would be struck down as void.
That is incredibly reassuring.
No.
Now, just before we list the rights themselves, let's talk about their features.
Yeah.
Are they absolute? Can I just say anything I want, anytime I want?
No, not at all. They are not absolute. They're qualified. The state can impose reasonable restrictions on them.
Reasonable. There's another one of those lawyerly words.
It is. It's a balance between your individual liberty and the needs of society. But crucially, whether a restriction is reasonable or not is decided by the courts, not by the government that's imposing it.
And it's important to mention, not all of these rights are for everybody, are they?
That's right. Some are for citizens only. For instance, Article 15, which prohibits discrimination, or Article 19, which gives you freedom of speech, those are for citizens. But others, like Article 14, equality before law, and Article 21, protection of life and liberty, those are for all persons. Citizens, foreigners, corporations, anyone.
Okay. And what happens in a crisis, like a war or a national emergency?
During a national emergency, most of the fundamental rights can be suspended. But, and this is a vital exception that was added by the 44th Amendment after the emergency in the 1970s,
Right.
the rights guaranteed by Articles 20 and 21 can never be suspended, even during an emergency.
Articles 20 and 21, that's protection against being wrongly convicted of a crime and protection of your life and liberty. So even if the country is at war, the state can't just, execute you without any procedure.
Exactly. That right remains sacrosanct.
Okay, let's dive into the specifics. We have 6 main categories, and Section 2 of our deep dive is the right to equality. This covers Articles 14 all the way through 18.
It all starts with Article 14, equality before the law and equal protection of the laws.
Now, these sound almost identical, but our source material is clear that they're actually 2 different concepts, one from Britain, one from the U.S.
They are. Equality before the law is a British concept. And you can think of it as a negative concept. It means the absence of any special privileges for any person. The prime minister and a common farmer are both subject to the same ordinary law of the land.
Nobody is above the law. Simple enough. What about the American one?
Equal protection of the laws. This is a positive concept. It means equality of treatment under equal circumstances. Basically, it means likes should be treated alike.
So you treat people in similar situations similarly, but you can treat people in very different situations differently.
Precisely. For example, it's not a violation of equality to have a progressive tax system where a billionaire pays a higher percentage of tax than a middle-class worker. You're treating different classes differently to achieve a more equitable outcome.
And that idea really sets the stage for Article 15, doesn't it? The one that prohibits discrimination.
It does, but you have to read the fine print very carefully here. Article 15 prohibits discrimination on grounds only of religion, race, caste, sex, or place of birth.
That word only is doing a lot of work there.
A huge amount. It means the state can discriminate on other grounds. For example, some states have residency requirements for certain jobs or benefits. That's technically discrimination based on place of residence, not place of birth, so it can be permissible.
But Article 15 also has these famous exceptions. The state can actually discriminate, but in favor of certain groups. This is what we call protective discrimination.
Right. This is the constitutional basis for things like affirmative action or what's known as reservations in India.
Okay, so what does it allow?
It allows the state to make special provisions for women and children. It also allows for special provisions for the advancement of any socially and educationally backward classes of citizens, which includes the scheduled castes, or SCs, and the scheduled tribes, the STs.
And more recently, a whole new category was added to this, the EWS.
Yes, the economically weaker sections. This was brought in by the 103rd Amendment Act in 2019. It added another exception allowing the state to make special provisions, including up to 10% reservation in educational institutions for EWS.
Now, the source has some very specific criteria for who qualifies as EWS. It's not just a feeling, it's based on data.
It is. It's strictly means tested. To be identified as EWS, your family's gross annual income has to be below 8 lakh rupees.
But it's not just about income, is it?
No, there are asset limits too. You're excluded if your family owns 5 acres of agricultural land or more, or a residential flat of 1,000 square feet or more in a notified municipality. So it's trying to target a very specific group.
Okay, now Article 16 is a lot like 15, but it's specifically about jobs, public employment. This is where the big debates about job reservations really happen.
Absolutely. Article 16 guarantees equality of opportunity in public employment. But again, it has exceptions that allow the state to provide for the reservation of posts in favor of any backward class that is, in the opinion of the state, not adequately represented.
And this brings us to the Mandel Commission. You can't really talk about Indian politics or society without mentioning Mandel.
Impossible. The Mandel Commission was set up in 1979 to identify these socially and educationally backward classes. It came back with a list of over 3,700 castes and recommended a 27% reservation for them in government jobs. These are the other backward classes, or OBCs.
And when this was finally implemented in 1990, it just transformed the country's politics.
It really did. It was immediately challenged in the Supreme Court, leading to the famous Mandel case of 1992. The court upheld the 27% reservation for OBCs, but it introduced a crucial filter.
The creamy layer.
The creamy layer. It sounds like something you'd find on a pastry.
It does.
But the court ruled that the advanced sections among the OBCs, the creamy layer, must be excluded from the benefits of reservation.
So who falls into that category?
People like the children of constitutional post holders, senior government officers, professionals like doctors and lawyers, or families with an annual income above a certain threshold, which is currently also 8 lakh rupees.
So the logic is that the benefit should go to the person who actually needs it, not someone who's already privileged despite belonging to that caste.
That's the idea, yes.
Okay, let's rack up the equality section. We have Article 17, which abolishes untouchability.
And this right is absolute. There are no restrictions on it. It forbids the practice of untouchability in any form. It's interesting, though, the word untouchability itself is not defined anywhere in the Constitution.
So how do the courts interpret it?
They've held that it refers to the historical social disabilities imposed on certain classes of people simply because of their birth in certain castes.
And finally, Article 18, abolition of titles.
This prohibits the state from giving out any title, unless it's a military or an academic one. So you can be a general or a doctor, but not a Maharaja.
No more Haidars or Diwans. We are a republic, not a kingdom.
That's the spirit of it.
But what about the national awards? Things like the Bharat Ratna or the Padma Awards.
That's a great question. The Supreme Court looked at this in 1996 and upheld their validity. It ruled that they aren't titles in the sense that Article 18 prohibits, because they are awarded for merit, not based on heredity.
But there was a condition.
Yes, a very important one. The court said that these awards cannot be used as prefixes or suffixes to the awardee's name. So you can't legally call yourself Bharat Ratna Sachin Tendulkar.
Good to know. I'll remember that if I ever win one. Okay, let's move on to Section 3. The right to freedom. Articles 19 to 22. This is the stuff that really makes a democracy feel like one.
And Article 19 is the big one. It's a cluster of 6 freedoms. Freedom of speech and expression, the right to assemble peacefully, to form associations or unions.
To move freely throughout India, to reside anywhere, and to practice any profession.
Correct. There used to be a 7th one, didn't there?
There did. The right to acquire, hold, and dispose of property. But that was deleted from this list by the 44th Amendment Act in 1978. It's no longer a fundamental right.
We'll come back to where that went later.
For sure. But let's talk about that first freedom, speech and expression. Can I say absolutely anything I want?
No. As we said, none of these are absolute. Your freedom of speech can be restricted by the state on grounds like the sovereignty and integrity of India, security of the state, public order, decency, morality, or defamation.
The classic example of not being able to shout fire in a crowded theater.
Exactly. But the courts have interpreted freedom of speech very, very broadly over the years.
How so?
Well, it explicitly includes freedom of the press. It also includes the right to know what the government is doing. It includes the right against having your phone tapped. And interestingly, it even includes the freedom of silence.
The right to remain silent.
Yes, you cannot be compelled to speak or listen.
Okay. Moving to Article 20. This is all about protection if you're accused of a crime.
It gives you 3 key protections. First, no ex post facto law. This means you can't be punished for an act that wasn't illegal when you did it.
You can't change the rules of the game after it's over.
Exactly. Second, no double jeopardy. You can't be prosecuted and punished for the same crime more than once. And third, no self-incrimination. You can't be forced to be a witness against yourself.
Which brings us to the giant, Article 21. If Article 32 is the soul of the Constitution, Article 21 has to be its beating heart. Protection of life and personal liberty.
It is, without a doubt, the most dynamic and evolving article in the entire Constitution. Originally, in the Gopalan case in 1950, the Supreme Court took a very narrow view.
What was that view?
It held that Article 21 only protected you against arbitrary executive action, not legislative action.
So if a policeman decided to lock you up without reason, Article 21 protected you. But if Parliament passed a law saying, we are now locking up everyone who wears a blue shirt,
right,
that would have been okay.
According to that early interpretation, yes. As long as there was a procedure established by law, the court felt its hands were tied. But then everything changed in 1978. The Maneka Gandhi case.
What happened there?
The government had impounded Maneka Gandhi's passport in the public interest, but refused to give her a reason. She went to the Supreme Court. And the court completely rewrote the rules for Article 21.
They essentially imported the American concept of due process of law, didn't they?
They did. They ruled that just having a law isn't enough. The procedure established by that law must be reasonable, fair, and just. It can't be arbitrary, fanciful, or oppressive. And that just blew the doors wide open.
It opened the floodgates in a good way. Because suddenly, right to life didn't just mean the right to not be killed.
Precisely. The court held that the right to life means the right to live with human dignity. And from that single idea, the judiciary has derived this incredible, expanding list of implied rights.
Like what?
The right to privacy, the right to health, the right to free legal aid, the right to a speedy trial, the right to travel abroad.
I saw the right to sleep in our notes. That has to be my favorite.
Yes, the right to sleep. The court has ruled that sleep is essential for a healthy life, so disturbing it without a valid reason is a violation of Article 21. It's an amazing example of judicial activism.
It really is. And there's also Article 21A, the right to education.
Yes, that was added later. It makes education for children between the ages of 6 and 14 a fundamental right.
Okay, so we have this massive, expansive right to liberty in Article 21. But right next to it, we have Article 22. And this one feels a bit darker. Protection against arrest and detention.
It's a real paradox. The first part is straightforward. It guarantees rights to people under ordinary arrest. You have to be informed of the grounds of your arrest, you get the right to a lawyer, and you must be produced before a magistrate within 24 hours.
Standard criminal procedure stuff you see on TV.
Right. But then there's the second part of Article 22, and that deals with preventive detention.
The minority report provision. Arresting someone not for a crime they've committed, but for one you think they might commit.
That's essentially it. It's detention without trial, based on suspicion.
And this is in the Constitution's chapter on fundamental rights.
It is. Our source material notes that it's quite unfortunate that no other major democratic country has made preventative detention an integral part of its constitution like India has. In the U.S., it's basically unknown. In Britain, it was a wartime measure.
So why? Why would the framers, who had just spent their lives fighting for freedom against the British, put something like this in?
You have to remember the context of 1947 and the years that followed. The trauma of partition, widespread communal riots, the difficult process of integrating hundreds of princely states. The nation was incredibly fragile.
So they felt the state needed this, well, this very heavy-handed tool to just hold the country together.
It was viewed as a necessary, if unfortunate, evil. But it's been controversial ever since. We've had a series of these laws, MISA, TADA, POTA, and the current UAPA. They allow for detention without trial for extended periods, although there are some safeguards.
It's a really stark reminder of that constant tension between individual liberty and state security.
It is.
Let's move to Section 4. We're looking at exploitation, religion, and culture. First up, Articles 23 and 24, the right against exploitation.
Article 23 prohibits traffic in human beings and also something called bigar.
Bigar. What is that?
It's a term for forced labor, usually without payment. It was a practice in the old feudal systems where landlords would compel tenants to work on their land for free. Article 23 bans that and any similar form of forced labor.
And Article 24?
That's about child labor. It prohibits the employment of children below the age of 14 in any factory, mine, or other hazardous activity.
Very clear-cut. Okay, now freedom of religion. Articles 25 to 28. India is a secular state, but it's a very different kind of secularism from, say, France, where religion is kept out of the public square.
It's a very different model. Article 25 gives every person freedom of conscience and the right to freely profess, practice, and propagate their religion.
Let's double-click on that word, propagate. It's a sensitive one. Does that mean I have a fundamental right to convert other people to my religion?
That is a very important and legally contested point. The Supreme Court has clarified this. You have the right to transmit and disseminate your religious beliefs. You can explain the tenets of your faith to others.
But
the court has held that propagate does not include a right to convert another person.
what's the distinction they're making?
It's about coercion, fraud, or allurement. But even beyond that, the court's logic is that the act of conversion impinges on the other person's freedom of conscience, which is also a fundamental right. So your right to propagate ends where their right to conscience begins.
That's a fascinating and very delicate balance.
Yeah.
And the Constitution also makes some specific cultural notes here, doesn't it? Something about Sikhism.
It does. Article 25 has an explanation that says the wearing and carrying of kirpans is deemed to be included in the profession of the Sikh religion. It's a rare example of a specific religious symbol being explicitly protected in the Constitution.
And what about religion and money? Can the government tax me to promote a specific religion?
No. Article 27 is clear. No person can be compelled to pay any taxes for the promotion or maintenance of any particular religion. The state can't use public tax money to favor one religion over another.
And what about in schools? Can they have religious instruction?
Article 28 deals with this. In any educational institution that is wholly maintained by state funds, religious instruction is completely prohibited. In other institutions that might receive aid from the state, it's permitted, but only on a voluntary basis. No student can be forced to attend.
Okay. Now, the last couple of rights in this section, cultural and educational rights, Articles 29 and 30, these are often called the minority rights.
Article 29 protects the interests of minorities. It gives any section of citizens with a distinct language, script, or culture the right to conserve it.
Any section of citizens. So that could be the majority too.
That's a very sharp point. The Supreme Court has held that, yes, the wording of Article 29 is not restricted to minorities only, it's wider. But Article 30 is different.
How so?
Article 30 is specifically for minorities, whether they're defined by religion or by language, and it gives them the right to establish and administer educational institutions of their choice.
And this is why we see so many schools and colleges run by specific religious or linguistic trusts, they have more autonomy under Article 30.
They do. It's a right intended to give minorities a sense of security, so their culture and identity aren't just swallowed up by the majority culture. The source does stress, though, that this is about ensuring equality with the majority, not putting minorities in a more advantageous position. The right to administer doesn't mean the right to maladminister.
Right. Okay, so we've gone through this whole list of rights. We have equality, we have freedom, we have protection from exploitation. But like we said at the very beginning, a right without a remedy is just, I don't know, poetry. It's useless.
It's meaningless.
And that brings us to Section 5, the heart and soul, Article 32.
Dr. B.R.M. Bedkar, the architect of the Constitution, called Article 32 the very soul of the Constitution and the very heart of it. Because this article is what gives you the right to a remedy if your other rights are violated.
This is where we get those amazing Latin terms that sound like spells from Harry Potter,
Yeah.
the writs. I really want to break these down so our listeners can actually picture how they work.
Let's do it. These are incredibly powerful orders that can be issued by the Supreme Court and also by high courts under a different article.
First up, the most famous one, habeas corpus.
The literal translation is to have the body. So imagine a friend or family member is picked up by the police and then they just vanish. No charges, no phone call, nothing. You would file a writ of habeas corpus.
And what does the court do?
The court issues an order to the police or whoever has detained that person, and it says, produce the body before us.
And if they can't show a lawful reason for the detention?
The person walks free. Immediately. It is the ultimate safeguard of individual liberty against illegal detention. And it can even be issued against private individuals, not just the state.
Incredible. Okay, next one. Mandamus.
This means we command. This writ is for when a public official is just not doing their job. Let's say you're entitled to a government license, you've submitted all the correct paperwork, but the officer in charge just refuses to process it.
So I get a mandamus writ, and the court basically tells that officer, do your duty.
Exactly. We command you to perform the duty that you have failed or refused to perform.
Okay, then we have prohibition.
Which means to forbid. This is a writ issued by a higher court to a lower court to stop it from exceeding its jurisdiction. It's preventative.
So the higher court is saying, whoa, stop. You don't have the authority to hear this case. Stay in your lane.
That's a perfect way of putting it. And closely related to that is certiorari.
Meaning to be certified.
Right. And while prohibition is purely preventative, certiorari is both preventative and curative. A higher court issues it to a lower court to either transfer a pending case to itself or to quash an order that the lower court has already passed.
So it's either we're taking this case over now, or your decision is canceled because you got it wrong. And the last one is quo warranto.
Which means by what authority? This is used to challenge a person's claim to a public office. If you believe someone has illegally taken over a government post they aren't qualified for, you can file this.
And the court then asks that person, by what authority are you holding this office? Prove it.
Precisely. It's like the imposter syndrome writ. Show me your badge.
I like that. So these writs are what turn the Supreme Court into a real watchdog with teeth.
Yeah.
But as we get to the end, we have to talk about the exceptions. The places where the Constitution gives with one hand and seems to take away with the other. Section 6.
We have to talk about what our source calls the vault. This is about Article 31B in the 9th schedule of the Constitution.
That sounds very mysterious.
It was created by the very first constitutional amendment, back in 1951. It was designed to be a kind of legal safe house for laws, mostly land reform laws at the time.
A safe house.
The government would pass a law, and if they were worried it might be challenged in court for violating fundamental rights, they would place that law into the 9th schedule. Once a law was in that schedule, it was immune from judicial review. The courts couldn't touch it.
That sounds like a constitutional cheat code.
Well,
I'll make a law, put it in this magic box, and now you can't tell me it's illegal.
And it was used like that for decades. But the story doesn't end there. In 2007, in the Ira Coelho case, the Supreme Court finally closed this loophole.
What did they say?
They essentially said, the game is up. They ruled there could be no blanket immunity. Any law placed in the 9th schedule after April 24th, 1973...
The date of the Kesavananda Party basic structure judgment.
Exactly. Any law added after that date is open to judicial review if it violates the basic structure of the Constitution.
The judiciary drew a line in the sand on that day. Okay, we should also quickly mention the armed forces.
Yes. Article 33. This allows Parliament to restrict or even take away the fundamental rights of members of the armed forces, paramilitary forces, police, and intelligence agencies.
To ensure discipline, I imagine.
That's the rationale. You can't have soldiers forming a trade union or going on strike in the middle of a war. National security requires a different standard of discipline.
And Article 34 deals with martial law.
Yes.
Yeah.
Martial law is military rule where the ordinary court system is suspended. It's different from a national emergency.
Okay, and finally, let's close the loop on that missing right we mentioned, the right to property.
Right. As we said, it was deleted from the list of fundamental rights by the 44th Amendment in 1978. It was moved and is now just a legal right under Article 300A.
So what's the practical difference for me, the listener, if it's still a legal right?
The big difference is the remedy. If the government takes your property today, you are still entitled to compensation and due process. But you can't go directly to the Supreme Court using Article 32. It's not a fundamental right violation anymore.
So I have to file a regular lawsuit and go through the whole court system from the bottom up.
Exactly. It takes longer, it's harder to fight, and crucially, since it's no longer a fundamental right, it's not considered part of the basic structure. This means Parliament has much more power to regulate it.
So we've covered this huge, complex landscape of rights. But our final section asks us to be critical. Is this system perfect?
Oh, far from it. One of the oldest and most common criticisms is that the Indian Constitution is a paradise for lawyers.
Because the language is just dense and complicated?
Yes. The language is often vague. Phrases like public order, reasonable restriction, minorities, public interest, they aren't clearly defined. And this ambiguity leads to endless litigation. You need a very good and probably very expensive lawyer to argue what reasonable means in the Supreme Court.
So the rights are there on paper, but only if you can afford the fight to enforce them.
That is a very real problem. Another major criticism is the lack of social and economic rights in this chapter. There's no fundamental right to work, for example, or a right to Social Security.
Those are in a different part of the Constitution, aren't they?
They are. They're in the directive principles of state policy, which are like goals for the government, but they are not justiciable. They are not enforceable in court.
And of course, the big one we already discussed, the existence of preventative detention. It just feels like a stain on a chapter about liberty.
It is. Many critics argue it takes away the entire spirit of the rights and gives far too much arbitrary power to the state.
But despite all that criticism,
Despite all that, the significance of these rights is immense. They are the absolute bedrock of Indian democracy. They are a check on the government's power, they protect minorities, and they establish the principle of individual dignity. Without Part 3, the whole democratic system would likely collapse.
it's a living document. It's constantly evolving. You can see the journey from the 1950s, when right to life had a very narrow meaning, to today where the courts say it includes the right to privacy.
And that evolution, through judicial interpretation, is the key to its survival.
So here is a final provocative thought to leave you with. We talk about how these rights were designed to establish a government of laws and not of men. But these laws, these protections, were written in 1950. In today's world of, digital surveillance, social media manipulation, AI, and the immense power of tech giants who sometimes act like states themselves, are these 1950-era protections evolving fast enough for the digital age? We have a right to privacy now, but is the Magna Carta of India really ready for the metaverse of India?
That is probably the defining legal and constitutional battle of the next 20 years. And that basic structure doctrine is going to be tested in ways its creators could never have imagined.
Something to think about the next time you're scrolling through your phone. If you enjoyed this deep dive into the rules that rule us, please do like and subscribe to the channel Daily Deep Dive. We will be back with more insights very soon.
Thank you for listening.
See you next time.